Hi, my objective with this video is to provide you with a snapshot of privacy principles in the United States and to give you a feel for how they are applied. So, right out of the gate, here's the basic concept. Privacy rights are violated when there is an intentional intrusion on private affairs that would be highly offensive to a reasonable person. For starters, I want you to think about what it means for an action to be offensive. Let's say that somebody has intentionally harmed you in some way that you think might not be appropriate. Your reaction is, "Why did you do that?" And let's say this person offers you a reason that seems pretty lame under the circumstances. It's certainly not sufficient for what they have done. And so, weighing the harm in light of the explanation, you might conclude that what they did is pretty offensive. On the other hand, if they give you a rationale that seems appropriate, you might say, okay, I don't like what happened, but under the circumstances, I understand why you did it. And for that reason, your actions are not offensive. Basically, when we address privacy rights, we mentally engage in this kind of balancing act. On one side, we consider the degree of the intrusion on reasonable expectations of privacy. Or, in other words, how invasive were your actions and how much harm did you do? On the other side, we weigh the reasons for engaging in the conduct that violates privacy. And so the greater the harm, the better your reasons have to be. And if typical people would not believe the reasons justify the consequences, then that will be deemed a privacy rights violation. And I do want to emphasize here that the standard is whether a reasonable person would find the intrusion to be offensive under the circumstances. Some people are just hypersensitive to certain kinds of things and don't react the way most of us do. You might simply touch someone softly in a crowded environment, and they could go all nuts about it and scream about how you violated their personal space or whatever. But that's probably not how most reasonable people would react to an intrusion such as this. The same considerations are relevant with privacy. For this reason, we talk about reasonable expectations of privacy and whether a reasonable person would find the intrusion offensive. So, I'm going to spend most of the time in this video evaluating various factors that might affect the outcome of the privacy balance, and thus whether an intrusion might be considered offensive to a reasonable person. But just for completeness, I want to first give you some perspective about the laws underlying privacy rights in the United States. So, there we go. So the initial thing I put on here as a source of privacy policy in the United States is the US Constitution. And I put it first because so many people misunderstand its role in the privacy fabric. I often hear statements like, "That business can't have cameras in the lobby. It's unconstitutional." Well, it may not be lawful, but probably not because it violates the US Constitution. The Constitution essentially says that no government shall interfere with certain protected rights. I want to emphasize that the restriction is on what government can do. That may be the federal government or the state government. It also applies to their employees. So, as a professor who works for the state of California, if I were to do something that offended you in terms of privacy, then it is possible that my action is unconstitutional. In addition, if the government passes laws that interfere with protected rights, then those laws may be unconstitutional. This effectively means that you don't have to comply with the laws, and they may be stricken. Well, so what does the Constitution say about privacy? Well, you kind of have to dig a little bit to find it. The Fourth Amendment probably is where privacy is protected most directly. It provides that governments cannot engage in unreasonable searches and seizures of your person and certain property. This is clearly meant to prevent the government from intruding to some degree on your privacy in an unreasonable fashion. The First Amendment protects freedom of speech and religion, which may entail some privacy issues. For instance, you may have some rights to speak anonymously and thus keep your identity private under the First Amendment. Oh, also, the 14th Amendment provides that government can't interfere with your liberty. And some people believe that those liberty interests include notions of privacy. For instance, a woman may have the personal freedom to make decisions about private matters, such as her decision to terminate a pregnancy. Thus, overall, I want you to recognize that the US Constitution does protect privacy to some degree, but again, it only addresses actions undertaken by the government. I put state constitutions on here because sometimes they may also protect privacy. In this regard, the California Constitution is notable because it states that each California citizen has an inalienable right to pursue privacy. Thus, in California, the state constitution may protect our privacy not only from government action, but also from things that private businesses or individuals do. The next source of privacy may be the most important. It's the common law. Those of you who have had a business law or an introduction to law class have probably heard about this. For now, let's just say that the common law is established by judges who must determine fair principles based on community norms and standards to decide cases that are before them. These principles then become part of the guiding policies that govern our conduct. So the basic notion of a privacy right violation is actually based on the common law. These concepts from the common law are also very often used in other contexts, such as with constitutional protections. The last thing I want to mention here, right there, is that there are some government statutes and regulations that specifically protect privacy. These are basically laws passed by legislatures or government agencies. And we have them at the federal and state levels. So, for example, at the federal level, there is the Children's Online Privacy Protection Act, which establishes some specific methods that online businesses must use before acquiring information from children under the age of 13. Oh, and at the state level, California has passed a consumer privacy law, which specifically requires websites to take certain steps before collecting data from customers in the state. Oh, this law also was enhanced by Proposition 24, which the voters supported in 2020. Anyway, this is something we may take a closer look at during a class session. Okay, no matter the source of protection, the overriding principle that governs privacy is whether the intrusion would be offensive to a reasonable person. And as I already suggested, there are several factors that may influence whether an action, at the end of the day, may be considered offensive. For any situation, many of these factors may be relevant, and usually no one of them will be controlling or be most important. Often, a combination of factors will explain one's gut feel that an action is or is not offensive. So just take to heart that a lot of things might matter before deciding whether an activity is offensive or not. All right. Given that the privacy balance weighs the purpose for any action, against the degree of intrusion on private matters. It should be obvious that one of the relevant factors has to be the reasons for the privacy intrusion. And the more important the reasons, the less offensive the intrusion will likely seem. So I like to use the example of drug testing when first thinking about these factors, because you may have experienced it and the issues are pretty tangible. After you get a feel for what the factors mean, it is easier to then apply them to more high-tech circumstances. Oh, just for clarity, sometimes when we consider drug testing, we are thinking about pre-employment testing, and other times it's random testing for current employees. Random drug testing means that when you come to work, you never know if you will be pulled aside for a drug test that day. So let's start with this. An employer requires random drug testing for its security officers or for truck drivers. What's the reason for this? Well, these are individuals who can do a lot of harm if they are high, either by mishandling firearms or having an accident. You don't have the luxury to wait and see if they are acting as if they may be on drugs, because by then it may be too late. Thus, for these folks, there are strong rationales for using random drug testing to increase their incentives to refrain from drug use at all times. On the other hand, what would you say if the random drug testing program includes receptionists who only answer phones or do light typing? Sure, they could do harm if under the influence. Maybe they could offend a potential client or something. But the repercussions would likely be far less than what we are talking about with a security guard or a truck driver. At the same time, the employer will be learning information about what the receptionists do when not at work, such as smoking marijuana several weeks ago at a weekend party. So is this offensive? Well, not necessarily. The employer may still have decent reasons for the drug tests, such as to protect its reputation. The need just isn't as significant as it might be for other kinds of employees. But still, if the company takes sufficient steps to minimize the intrusions on expectations of privacy, then the overall balance could still tip towards reasonableness. And this is where the other factors may come into play. Oh, and before moving on, I'll add here that once you have a reasonable suspicion that a person has engaged in potentially harmful behavior, then your rationale for intruding on privacy increase, or may increase at least. Thus, if you have evidence that an employee has come to work high, then you may have more significant reasons to test that employee. The next factor that is often relevant is whether the extent of the privacy intrusion is limited to the company's legitimate purposes. For instance, a company may very well have an interest in knowing whether you take certain recreational drugs, even while not at work. Thus, it may be acceptable to have a random drug testing program which informs the employer about such matters. But those giving drug tests, such as urinalysis, may learn much more from the procedures. For instance, the test may indicate whether a woman is pregnant, or it may disclose that the employee is taking certain prescription drugs, such as Prozac for depression. And you might think, I understand why you might want to know if I use cocaine or smoke weed, but you have no reason to learn about these other matters which I wanted to keep private. Thus, the collection of this information may seem offensive. Now, there are procedures that can be used with drug testing programs so that the employer only obtains information about the recreational drug use. The lab, for instance, can be instructed to only forward the relevant findings to the employer. And there are also procedures so that the lab personnel can't link the full test results to personal names. Therefore, If the company adopts these measures, then it will limit the extent of the intrusion to its purposes regarding recreational drugs, and consequently, the program will likely seem less offensive. Oh, we can also extend this principle to monitoring communications. Take old-style landline technology. Companies might have policies allowing managers to listen in on sales calls to ensure their employees were appropriately polite and professional with customers. And that might be fine. But if the manager picked up and heard the employee say something like, "Hi, Mom, it's nice to talk to you today," then the manager should hang up because the discussion is clearly not related to the company's business purposes. These same considerations may arise when employers monitor email or text messages. If they have procedures that perhaps allow managers to view only business-related content and prevent them from seeing purely personal statements, then the program may seem less offensive. Okay, next on this list of factors is notice and consent. Probably no surprise here. When someone notifies you that they intend to review what you are doing, then that should lessen your expectations that your behavior will remain private. For instance, Cal Poly provides me with a computer and internet access in my office on campus. I spend a lot of time preparing classes or conducting research with these resources, but sometimes I need a break. So I might take a little time and search airline travel sites or download music, or maybe even visit unscrupulous sites. It doesn't matter. My door is closed and nobody can see me. So, imagine my surprise when the dean walks into my office one day and tells me how disappointed he is that I download so many tunes and that I visited Playboy last week. He also is angry that I sent a note over my Gmail account that said nasty things about the university's president. I'm like, "How did you find out about that?" and he tells me that my computer has a keystroke monitor on it, so his staff knows every thought that I type, even when I erase it. And so I'm shocked that the college has been watching me when I thought I'd been secure in the privacy of my closed office. Cal Poly might care about the bandwidth I use, the types of sites I visit, when I engage in personal use, and for how long. Nonetheless, I find all this scrutiny to be very offensive. Now, if the college had told me that they monitor my internet usage and had installed a keystroke monitor, then I would have been much more cautious knowing that someone might be watching. And so the notice reduces my expectations of privacy, which overall makes the situation seem less offensive. Also, if I consent to the monitoring, then it's harder for me to later complain that I wasn't aware of the notice. And as we go through these factors, I want to be very clear that Cal Poly's monitoring may still violate privacy rights, despite the notice. Notice is helpful, but it is still only one of several factors that may bear on whether the actions are offensive. It's possible, for instance, that the school just didn't have sufficient reasons to engage in such widespread monitoring, or it read more personal material than warranted. And then there are other factors which we're about to address, such as who learned what I had done, and what were the repercussions. Okay. Another factor that can affect the analysis is the context of the intrusion. To highlight what this means, I want to start with two examples that are polar opposites of each other. Here's example number one. Let's say I live in a home that has a big front window that faces the street. The house is somewhat close to the sidewalk so that Anybody who walks by can easily see me through the glass. Okay, so one very warm morning, I walked downstairs without putting on my clothes to get a cup of coffee. I then go to the window to see what kind of day it is, you know. And while I'm there, a couple of people who are walking by on the sidewalk, they pause, and I can tell that they are looking right at me. And my reaction is, whoa, I can't believe that they are doing this. They are violating my privacy. Okay, I'm sure you're thinking, Lee, you're just an idiot. How could you possibly have expected any privacy when you were standing in front of a picture window for the whole world to see? Honestly, I might not like that they saw me naked, but it wasn't their fault. It was my fault. Thus, in this context, I say that there is no expectation of privacy. My contrasting example is based loosely on the movie Revenge of the Nerds, um, which I actually recommend if you haven't seen it. So, we have a bunch of fraternity brothers who surreptitiously sneak into a sorority and plant cameras in a bathroom and in bedrooms. They then go back to their house, sit on the couch, drink beer, and watch the show. What do they see? Sorority members taking showers and undressing and whatever while in these rooms while the shades are drawn. So you get the idea. And of course, you recognize that the women have significant expectations of privacy under these circumstances. So the context of this intrusion here is very different than in the first example. Well, you don't often get situations that are so cut and dry like these two examples. Usually the context is a little more gray. So here is another example that has a hint of truth to it. As you may have noticed by my companion in some of these videos, I love golden retrievers and have had them for as long as I can remember. Sometimes I've had one, sometimes two. I even had three once, although I don't really recommend having that many. If you have dogs, you know there aren't a lot of convenient places nearby in San Luis Obispo where you can let them run free. Anyway, for a while, my solution was to take them on the weekends to the lawn in front of the business building on campus. So, one Sunday, I put my then two golden retrievers in the car and drive them to Cal Poly. They know where they're going, and when I pull up to park, they get all excited, and they start whimpering and jumping around with excitement. I open the doors and tell them to go play, and bang, out they go. And I have a couple of tennis balls which I throw for them to chase. But this Sunday, I drank a lot of coffee, and then I just bolted out the door with the dogs without thinking about it. So, right after we get to the lawn, nature began calling, and very soon it was calling very loudly. Now, we had just arrived, and the dogs still had a lot of energy to burn. So I call them, and I bring them over to the first floor bathroom, but darn it, it's locked. And then I remember, oh, it's Sunday. Oh, golly. So everything's locked. So next I consider dragging them back into the car, driving them home so I can take care of business, and then I'll put them back in the car and drive them back to Cal Poly. But that seemed like it was going to be really burdensome. And the dogs were going to be confused about what's going on, and this is just not a great option in my mind. So then I start looking around, And, it dawns on me that, it is Sunday and I'm the only one around here. Um, and so, the camp it's pretty empty. And, well, so as you probably know, there's this enormous tree on the front lawn, in front of the business building. And so I begin thinking, hmm. So I look to the left and I look to the right and I look all around and there's just nobody to be seen here. So it occurs to me that maybe I could just play the odds. If I act fast, the only real risk, given that nobody's around, as far as I can tell anyway, is that somebody could maybe drive up front on the street at the bottom of the field. But I could take care of that by just stepping behind the tree. And so I did. And, when I was done, I look around again, just to see how it went. And frankly, it went quite well. There's nobody there. Nobody saw me. So all's cool. And so, I just go pick up the tennis balls and I resume playing with my dogs until they're tired and happy. And then I head home. Mission accomplished. And so I thought that was the end of it until about 3 hours later when I got a call from a colleague. Was a marketing professor named Norm Boren. And so he's like, "Hey, Norm," and he's laughing over the phone. And I go, it's like, "What?" And he says, "Lee, I can't believe you did that. I mean, this is a business school, but that doesn't mean that you should take care of your business like you did out there in front of Dexter Lawn." And I'm like, "How the heck did you know that?" It's like, "I didn't see you there." So then Norm replies, "It was on the internet site, man. You dodo. Don't you know that the OCOB has a camera on top of that building that is, pointed directly at that tree? It displays what's going on out there and streams the video 24/7. And I just happened to be watching this morning to check out the weather. Who knows how many other people saw it, but I'm sure they all got a kick out of it, Lee." So you can imagine how I felt. First, sure, I turned a little red with embarrassment. But then I also felt violated, as if someone had opened curtains into the sky without my knowledge and peered down on me. I mean, there I was, reasonably thinking that I was alone in that space on the lawn, only to learn later that people might be surreptitiously watching me. I imagine many of you are thinking, "Lee, you are on Cal Poly property at a very public location, so it's ridiculous to have an expectation of privacy." Well, I don't know if I totally agree with that. I'm not convinced that you always give up all notions of privacy when you are on public grounds or might conceivably be seen from a public space. I think even the Supreme Court might agree. For instance, when you drive your car, you realize that somebody might tell you to keep track of where you are. If you're concerned, you keep checking your rear view mirror, you might even look behind you. Just to see. But, would I expect somebody, like the police, to put an electronic monitor on my bumper and then follow me 24/7? And I wouldn't know about it just by, looking back like that? So, there is the problem of physically attaching the monitor to my property, which could be a form of trespass here. But beyond that, this constant monitoring in this way might violate my expectation of privacy, even though it all happens on public streets. So I'm going to tell you the Supreme Court has hinted that this is correct in cases involving these kinds of car monitors and also with GPS cell phone tracking. Google even ran into issues when it first introduced Street View. You know, to construct the service, Google had employees drive around and take pictures from public streets. Some of the photographs it posted displayed people's faces or the license plates on cars. And boy, did some people complain about the intrusions on their privacy. Think if, for instance, if you told your wife you were going to work, but then your car and license plate appear on Google Street View in front of, oh, the porn shop. And then the whole world, including your wife, might see it. Google faced so much heat about privacy issues that it had to come up with new procedures to obscure the faces and the license plates. So I don't think I would necessarily assume that a person gives up all expectations of privacy just by appearing in public. So back to the OCOB camera. In my opinion, it would have been nice if there had been a sign alerting me that the area was under surveillance or that a weather cam was active. Had I seen the notice, I doubt that I would have behaved the same way behind that tree. Okay, well, I don't know if that camera is still there. There was no sign when it operated. Does that mean Cal Poly violated the privacy of those walking on Dexter Lawn? Well, the reality is that the image was really grainy, and the individuals who appeared there were so tiny that you really couldn't identify who they specifically were. So when it comes to video surveillance, things like resolution can be relevant. Other factors also may come into play. Is the purpose for crime prevention or to detect speeding, which are obviously more important than displaying the weather? Do you limit the information needed for the purpose? For instance, high resolution is probably not needed to display the weather. For crime purposes, you might need high resolution. But then, do you limit who can see the video or how long it is retained? As always, the bottom line is whether a reasonable person would consider the intrusion to be offensive under the circumstances based on all the relevant considerations. Okay, so that segues into some of these other factors and how they might fit together. For instance, with drug testing, employees may try to beat a urine test in various ways. They might send others in to give the sample, or try to sneak in clean samples, or chemicals to mask the results. So the best way to fight these measures is to have lab personnel physically watch the individual produce the sample. Oh, and also have someone there who can verify the person's identity. But many people find it offensive to have others watch them urinate. So there are suitable procedures that companies can use to significantly reduce the risk of cheating the test without actually watching the individuals urinate. I imagine that many of you may have had testing with these alternate procedures. Still, others of you may have had people watch, and for these, there likely were more important reasons that justified the added scrutiny. Okay, well, while I'm thinking about procedures, you know that when you go through security at an airport, they ask you to raise your arms while they do a body scan. Some people don't like the scan for privacy or other reasons, and so can opt for a pat down if they prefer. This reduces the instances when reasonable people might be offended by the overall safety program. Oh, in addition, you need to be careful that you fairly implement the procedures to gather personal information. For instance, how would you feel if your company used random drug testing, but every week your number comes up? You may feel like you are being unfairly targeted. and that the clear act of discrimination is offensive. All right, let's buzz through the rest of the factors. The consequences of the intrusion can bear on whether privacy rights have been violated. For instance, let's say you fail a random drug test and you are immediately fired. You might think, whoa, that's a pretty big hammer for what happened here. It was the first time, and I'm not like a security guard or anything. Wow, that outcome is pretty offensive. On the other hand, what if you had a positive test, but you got to keep your job as long as you went to counseling or a rehab program? You might say, yeah, I understand why you have this testing program, and this consequence makes sense to me under the circumstance. And the last item, which I already mentioned, has to do with the confidentiality of the information that is collected. The intrusion will feel less offensive if the information is only made available to those who have a need to know it in order to fulfill the purpose of the activity. You also should strive to delete the information once the relevant time period for the purpose has passed. Okay, well, that pretty much covers it. To decide whether a business activity unlawfully intrudes on privacy rights, you will have to evaluate a number of factors. There are no hard and fast rules. Rather, you need to consider a wide spectrum of factors and options to determine if your actions are offensive to reasonable people. And this is true no matter what kind of activity you are talking about. It might be internet monitoring, video surveillance, cell phone tracking, data collection, drone activity, or the huge number of other activities that have become enabled with new digital technologies. If you have a project that potentially involves privacy, I hope that this summary proves useful. We will also discuss these matters further in class when we specifically address developing privacy issues. So until next time, I wish you very well.